How should the law treat a mentally disturbed person who commits a criminal offense? Should individuals whose mental faculties are impaired be held responsible for their actions? These questions are of concern to social scientists, to members of the legal profession, and to individuals who work with criminal offenders. Over the centuries, an important part of Western law has been the concept that a civilized society should not punish a person who is mentally incapable of controlling his or her conduct. In 1724, an English court maintained that a man was not responsible for an act if he doth not know what he is doing, no more than a wild beast. Modern standards of legal responsibility, however, have been based on the McNagton decision of 1843. McNagton, a Scotsman, suffered the paranoid delusion that he was being persecuted by the English Prime Minister, Sir Robert Peel. In an attempt to kill Peel, he mistakenly shot Peel's secretary. Everyone involved in the trial was convinced by McNagton's senseless ramblings that he was insane. He was judged not responsible by reason of insanity and sent to a mental hospital, where he remained until his death. But Queen Victoria was not pleased with the verdict. Apparently she felt that political assassination should not be taken lightly, and called on the House of Lords to review the decision. The decision was upheld and rules for the legal definition of insanity were put into writing. The McNagton rule states that a defendant may be found not guilty by reason of insanity only if he were so severely disturbed at the time of his act that he did not know what he was doing, or that if he did know what he was doing, he did not know it was wrong. The McNagton rule was adopted in the United States, and the distinction of knowing right from wrong remained the basis of most decisions of legal insanity for over a century. Some states added to their statutes the doctrine of irresistible impulse, which recognizes that some mentally ill individuals may respond correctly when asked if a particular act is morally right or wrong, but still be unable to control their behavior. During the 1970s, a number of state and federal courts adopted a broader legal definition of insanity proposed by the American Law Institute, which states, a person is not responsible for criminal conduct if at the time of such conduct, as a result of mental disease or defect, he lacks substantial capacity either to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law. The word substantial suggests that any incapacity is not enough to avoid criminal responsibility, but that total incapacity is not required either. The use of the word appreciate rather than know implies that intellectual awareness of right or wrong is not enough. Individuals must have some understanding of the moral or legal consequences of their behavior before they can be held criminally responsible. The problem of legal responsibility in the case of mentally disordered individuals is currently a topic of intense debate, and a number of legal and mental health professionals have recommended abolishing the insanity plea as a defense. The reasons for this recommendation are varied. Many experts believe that the current courtroom procedures, in which psychiatrists and psychologists for the prosecution and the defense present contradictory evidence as to the defendant's mental state, are confusing to the jury and do little to help the cause of justice. Some also argue that the abuse of the insanity plea by clever lawyers has allowed too many criminals to escape conviction. Others claim that acquittal by reason of insanity often leads to a worse punishment, an indeterminate sentence to an institution for the criminally insane that may confine a person for life, than being convicted and sent to prison, with the possibility of parole in a few years. Despite the current controversy, actual cases of acquittal by reason of insanity are quite rare. Jurors seem reluctant to believe that people are not morally responsible for their acts, and lawyers, knowing that an insanity plea is apt to fail, tend to use it only as a last resort. In California in 1980, only 259 defendants, out of approximately 52,000, were successful in pleading not guilty by reason of insanity.